Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial band sleeps reading. Chapter 4, The Courts. What was that about kings? Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Note again, there is no definition of judicial power. The judges, both the Supreme and inferior courts, shall hold their office during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Jobs for life and no pay cuts. Does this mean we're back to kings? Section 2. The judicial power shall extend to all cases arising under the Constitution, the laws of the United States, and treaties made, and to controversies. Here is one key to the federal courthouse door. Between citizens of different states. Here is another key to the courthouse door. For all that the framers of the Constitution consciously rejected the idea of a monarchy, they still established an independent judicial branch and gave it a lot of power, making federal judges a bit like mini-kings and queens. They also made it hard for the other branches, and impossible for voters, to fire them. This chapter talks about the power of the federal judiciary and how that power is kept in check by confining the kinds of matters that judges are able to consider in the first place. But first, let's get Marbury versus Madison out on the table. Marbury is considered to be the most important decision in constitutional law because the Supreme Court held in 1803 that American courts have the power to review actions by Congress and by the President in order to determine whether they comply with the Constitution. This outcome was not a given. President John Adams won the election in 1796. He was a member of the Federalist Party. Toward the end of his administration, the Federalists in Congress created a number of judgeships to shore up their power. Adams filled one of those slots by appointing William Marbury as a Justice of the Peace, an appointment that required the Secretary of the State to deliver a commission to Marbury. The delivery never happened. When President Thomas Jefferson took over in March 1801, the new Secretary of State, James Madison, refused to deliver the commission to Marbury. Marbury sued Madison, asking the Supreme Court to force Madison to turn it over under the judicial power to issue a writ of mandamus, a piece of paper that forces government officials to do their duties. Congress had given federal courts the power to issue writs of mandamus in the Judiciary Act of 1789, which created the lower federal courts too. The Supreme Court held that Marbury had the right to the commission, but refused to issue the writ forcing Madison to turn it over, concluding that the statute giving courts that power was itself unconstitutional. Notably, the Constitution itself does not declare that federal courts have the authority to strike down unconstitutional laws enacted by Congress. The Marbury Court came up with that rule, and the decision has stuck all these years. There would be nothing more concrete than respect for the rule of law to stop a renegade president from coming along and declaring that Marbury is wrong and that the president gets to interpret the Constitution how he sees fit. Indeed, Trump's pick for acting attorney general during the volatile special prosecutor days of 2018, Matthew Whitaker, makes this very argument. Yet, with Marbury, the court established the federal judiciary as strong and independent branch of the federal government. The Constitution was the supreme law of the land, it decided, and the judiciary was the final arbiter of what the Constitution means. Marbury is one reason why the Supreme Court nominations have become so politically polarizing today. Justices serve for life, and they refine the other branches' job descriptions. In addition to deciding how far the Constitution goes to protect individuals against an overbearing government. The keys to the federal courthouse door. There are two things you should know about the judicial branch. The first is that anybody can get before a court. She needs the keys to the courthouse door. There are two court systems in this country, state courts, each state has its own, and federal courts. For both of these, one key that is needed to get before a judge is a cause of action. As we've seen, Joe cannot sue Jane or help the government send Jane to jail for behavior that is not forbidden by some sort of law, whether that be the Constitution, a statute, a regulation, or a judge-made common law, also known as case law. Giving someone the stink eye is rude, but it can't send someone to jail or even to court. To get before any judge, whether a federal or state court judge, you need to have a cause of action. For federal court, you need yet another key. State courts can hear virtually any kind of case, but federal court's jurisdiction is limited. A plaintiff needs a dispute that raises a federal issue, like whether Congress has the power to make a particular law under the Commerce Clause, or whether an African American woman's federal boss violated the Civil Rights Act when he passed her over for a promotion. This is why the Constitution says that federal courts can hear cases arising under what amounts to federal law, or alternatively, for disputes that there are local in nature, e.g., a slip and fall at a shopping mall, federal courts can hear the case if the parties are from different states. This is what lawyers and judges call diversity jurisdiction, and it is also clear from the Constitution's language. The idea behind diversity jurisdiction is that even though there isn't anything federal about a slip and fall at a mall, unless, of course, we were talking about the National Mall in Washington, D.C., where the Smithsonian Institution and numerous federal buildings reside, federal courts are more likely to be fair to defendants from out of state than are elected state court judges. Imagine a slip and fall at a local hardware store in Plano, Texas. The person who fell is a multi-billionaire from Los Angeles who happened to be in town and swung by to pick up a book of matches. It is reasonable to presume that the local judge in the case will be biased in favor of the hardware store, particularly if that judge is elected and needs to make the neighbors happy if he wants to keep his job. By contrast, federal judges, like other principal officers in the executive branch, such as the Attorney General or Secretary of State, are appointed by the President and confirmed with the advice and consent of the Senate. Moreover, the Constitution makes clear that they have jobs for life, absent impeachment, and cannot pay their docked simply because they make decisions that are politically unpopular. A few more basics about courts. Most of the time, parties file cases in the lowest level courts, known as trial courts. Decision from those courts can be appealed to a higher court, known as a court of appeals. From there, decisions can be appealed to a Supreme Court. Each state has its own trials, appeals, and Supreme Courts. So does the federal judicial system. Appeals to middle-level courts are as of right. If you lose the case in the lower court, you get an appeal no matter what. Winners can't appeal just to rub it in. The Supreme Court of the United States is an ultra appeals court for states, meaning that parties can appeal state Supreme Court decisions to the U.S. Supreme Court. In the federal system, appeals from the intermediate appellate courts, known as the U.S. Circuit Courts for Appeals, also go to the U.S. Supreme Court. The thing is that the U.S. Supreme Court doesn't have to take on any one case. The justices pick and choose what cases they want to take, and the court takes only about 80 a year. Appeals to that court are made by what's known as a petition for a writ of certiorari. Justices vote on whether to grant cert using famous criteria. One thing to know about court structure generally, people who are in state court can't get a federal court to review a state court decision except by a cert petition to the U.S. Supreme Court. You can't leapfrog from one court system to another, in other words. With one exception, habeas corpus. Habeas is a topic that could find itself in several places in this book, under the chapter on Congress's powers, under the chapter on crimes under the Constitution, and here, in the chapter on the court's powers, because it's a way of getting a judge to review an unlawful detention. In Latin, habeas corpus means you shall have the body. The notion is that the government has arbitrarily put you in jail. You can petition the courts to get out. Keep in mind that a habeas proceeding is a separate from a direct appeal of your criminal case to higher courts in the ladder leading up from the U.S. Supreme Court. It is a side door channel to getting a warden to release you through a civil versus criminal proceeding. Congress has passed statutes governing the process, and the Supreme Court has issued lots of decisions, making this area of law very complicated and difficult to navigate without an experienced lawyer. Bottom line, if you're in custody, you can seek habeas review if you meet a number of procedural hurdles, but you're unlikely to win release this way. Additionally, few people realize that the Constitution does not create a federal judiciary other than the Supreme Court, and it does not specify how many Supreme Court justices there must be. In the Judiciary Act of 1789, immediately following ratification of the Constitution, Congress passed a law creating the lower federal courts. In theory, Congress could change its mind and eradicate all federal courts except the Supreme Court with a statute, and change the composition of the Supreme Court to just one justice. As distinct from the other branches, then the beauty and theory of the federal judiciary is that it cannot be influenced by power, money, or survival. The assumption instead is that the judges on the federal bench will make decisions neutrally, apolitically, and legitimately. The reciprocal problem is that federal judges are not tethered to the real-time will of the people. What is the sandbox for federal judges then? Article 3 allows federal courts to resolve cases and controversies, terms which are again undefined. The Supreme Court has filled in those blanks to say that the word case must mean something akin to what we see on Judge Judy, a discrete dispute involving distinct parties regarding events that occurred in the past. The rationale for this definition is that if courts are empowered to make decisions as to individual parties, we should be less concerned that federal judges aren't elected. The parties get their day in the court by showing up and arguing their case. Plus, the Due Process Clause enshrines that right, and the decision does not broadly affect lots of people like legislation does. Courts are also bound by higher laws, which include statutes and the Constitution, and Congress can override court decisions that interpret statutes. Thus, judges cannot just make up rules out of thin air by limiting the terms under which they function. Courts' power is held in the check even if federal judges aren't elected. Under the cases or controversies requirement, therefore, people have to show standing in order to get into a federal court. Standing means that if we agree that the judge's role is to call balls and strikes as to discrete parties, then we want to make sure those calls for legislative action do not get before a court. Imagine a plaintiff who tripped on a pothole in a sidewalk and broke her arm. She sues the city for damages, claiming that it was negligent in failing to repair the pothole. In other words, she wants a judge to say that a responsible city government that does its job would not allow a hazardous situation to continue until someone is hurt. The plaintiff walks into the court with her broken arm and says, "Look at my broken arm. It hurts so I can't go to work, and the medical bills are not in my budget, and I cry in pain all day, which I wouldn't have to do if the stupid city fixed its potholes." The court hears her story, and maybe with or maybe without the assistance of a jury, decides that the city was negligent and orders it to pay the plaintiff's doctor bills, give her money to make up for lost time at work, and give her more money to compensate for the pain and suffering it caused her. A difficult concept to quantify, to be sure, but that's how it goes. A judge makes a decision that affects those particular parties, but not necessarily the people who happen to be watching the proceedings in the courtroom or sitting on the jury. For other people, maybe someone whose car is damaged by running over a pothole 3 streets over, the judgment itself is not much help. He would have to file his own lawsuit against the city if he wants money to repair his car. He might get lucky and be assigned the same judge, who would presumably be inclined to rule in his favor, but if he is assigned a different judge, his lawyer will show the new judge the prior judge's decision involving the first person and say, "Me too." He will basically tell the judge that this case is just like the other one, so he should rule the same way. This is what judges and lawyers call judicial precedent or case law. Judges only resolve individual disputes, but their decisions can be used in later cases as a "me too." For his part, the city lawyer will say, "Not me," or "This situation is different." Maybe the second guy was drunk when he ran over the pothole, which had huge orange cones around it to make the drivers aware it was a hazard. The city can say, "Don't follow that other decision here, Judge, because we did the best we could to warn plaintiff number 2, and he brought the accident on himself." This is what lawyers and judges call distinguishing cases. Now imagine that a concerned citizen walks by the first pothole every day. He is aware of it and carefully steps around it. He pays his taxes and knows that eventually someone else will fall and get hurt. Can he sue to get a judgment directing the city to fix the pothole? Nope. He doesn't have a broken arm. He is like every one of the other hundreds of thousands of people who manage to walk around that pothole every day and don't have a particular dog in the pothole fight. The complaint about the city not repairing its infrastructure is a bigger one of a broader appeal. The law of standing, which confines federal courts' power to cases and controversies, would not let that guy into court. His gripe is with the city council, the legislative branch of the city, but the same idea holds true at a federal level. He can lobby the city legislature to pass a law requiring the city to fix potholes within 14 days once they reach a certain circumference, but not go to court. This question of standing came up with the court challenges to President Trump's first controversial executive order on immigration. The broken arm plaintiffs included people with family members who are barred from entering the United States, who claim to suffer from stress and anxiety as a result. But the problem with overly rigorous application of broken arm rule of standing is what constitutes sufficient injury to distinguish the plaintiff from the rest of the population is inherently subjective. If you have followed this discussion so far, I hope you have some sense of why it's really about constitutional theory and why it's more important. It is about constitutional theory because if the broken arm plaintiff can't go to court, she must go to the legislature. Standing law is therefore about separation of powers between the judicial and legislative branches. If the legislature is dysfunctional, which many would agree has been the case at the federal level for a while and for a number of reasons, then problems of great importance simply won't get fixed even if the people want them fixed. But the court system can also fail. Let's imagine a carpenter sues a restaurant owner for not paying a $10,000 invoice, and the restaurant owner ignores the court judgment directing that he pay up. The winner can go back to the judge. The judge can then direct another arm of government, the sheriff or the federal equivalent of a sheriff, the U.S. Marshal, to execute the judgment. This could literally mean marching into the restaurant and taking money out of the cash register, giving it to the carpenter. Again, without a cop on the block or hidden speed cameras, the rule of the law isn't worth the paper it's written on. One of the reasons why the American government is, or has been, revered around the world is that the rule of the law matters here. Judges' decisions are enforced. We live in a society where one of the cultural norms and values is that we mostly obey judges' orders. If people stop obeying court orders and get away with it, particularly at the highest echelons of government, our democracy is in big trouble. The relative power of the courts. Courts are especially critical in the structure of government because macro questions regarding how much government is too much often wind up there. In 1896, for example, the Supreme Court upheld a Jim Crow law requiring segregated railroad cars in Louisiana. Homer Plessy, a free man of 1/8 African descent, bought a first-class rail ticket and boarded a whites-only car in New Orleans. He was asked to vacate a seat and go to the coach used for the race to which he belonged. When he refused, he was arrested and fined. In rejecting Plessy's constitutional claim under the Equal Protection Clause, more on that later, the court conceded that the object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law. But with astonishing conviction, the court concluded that laws permitting or even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other. Emphasis mine. There was no constitutional right, in other words, to enforce a new social norm that would enable black people to mix with the white people, even if enforcement of that norm would effectively lift government bans on racial integration. In 1954, the Supreme Court overruled the decision in Mr. Plessy's case in Brown v. Board of Education, which declared unconstitutional a Kansas law permitting segregated schools for black and white children. The court relied on the Equal Protection Clause that the Plessy v. Ferguson court rejected as a means of enforcing social equality. Segregation with the sanction of law, the Brown court wrote, has a tendency to retard the education and mental development of Negro children and to deprive them of some of the benefits that would receive in a racially integrated school system. There was substantial social resistance to Brown. An Arkansas governor called the state's guard to prevent black students from entering a high school in 1957. A man named Medgar Evers sued to desegregate schools in Jackson, Mississippi, under Brown, and a member of a group called White Citizens Council, which was formed to resist schools integration, murdered him in 1963. That same year, an Alabama governor personally blocked an auditorium door to prevent black students from enrolling at the University of Alabama and moved aside only when President John F. Kennedy intervened, ordering a general of the U.S. National Guard, a part of the military forces reserve, to allow the black students to enter. 5 years after Brown, a Virginia judge charged Richard Perry Loving and Mildred Jones Jeter with a felony crime that made marriages between a white person and a colored person absolutely void. The judge reasoned that Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated those races showed that he did not intend for those races to mix. It was not until Loving v. Virginia in 1967 that the Supreme Court invalidated laws prohibiting interracial marriage, known as anti-miscegenation laws, on equal protection and other constitutional grounds. In marked different prose, Chief Justice Earl Warren wrote that marriage is one of the basic rights of man, fundamental to our existence and survival, and that there is patently no legitimate overriding purpose independent of invidious racial discrimination which justifies this classification, designed to maintain white supremacy. But was Plessy or Brown the better, truer construction of the plain language equal protection of the laws? Courts have a lot of discretion to make this kind of decision, and in an age of tweets and memes, it is easy to gloss over the meaning of individual words. Think about it. A strict reading of equal might look to its application in 1868 when the 14th Amendment containing the Equal Protection Clause was ratified after the Civil War. Presumably, the framers of the amendment believed that it had something to do with discrimination against African Americans by many southern states, so the clause can be fairly construed as assuring that the formerly enslaved persons received equal protection of the law, that is, that laws cannot discriminate against them based on their race, or more accurately, that they had to be equally protected under the law. What then does protection mean? In Plessy, the court appeared to construe the word without explicitly saying so, to not include protections from social norms that forbid black people from riding in rail cars with white people. The decision spawned the notion that separate can be equal. Blacks can be legally required to sit in public transportation, eat in restaurants, and go in school facilities that are separate from white people, so long as they receive equivalent seats, food, education, materials, and teachers, etc. But neither equal nor protection are defined in the Constitution itself. We might look further to a dictionary definition of equal as meaning the same measure, quantity, amount, or number as another. Unless black children can attend the very same school as white children, the clause is violated. But equal can also mean like, suggesting so long as the black children can attend a school that is like, i.e. similar to, a school in terms of the facilities, teacher, materials, etc., the black school can be considered constitutionally the same. A dictionary definition thus does not help us get to the plain meaning of the word equal under the Constitution. Moreover, it's impossible to achieve identical equality when it comes to making sure that the government treats people equally across age, gender, race, socioeconomic status, and so forth. The government certainly cannot be expected to put everyone up in an LA mansion or force those living in Beverly Hills to downsize to a one-bedroom condo so that everyone can be equal. A critic would rightly call that socialism, which our capitalist democracy most certainly is not. Interestingly, the same line of constitutional authority has been used to argue for the right to discriminate. In 1945, the Supreme Court heard a case in which a union of postal clerks claimed that a state law prohibiting racial discrimination in unions violated their property, liberty of contract, and social rights. Although the court rejected the notion that there is an individual right to discriminate, the argument that the Constitution provides a right to discriminate has resurfaced several times over the decades since, with scant success, including, for example, in a suit challenging a federal requirement that hotels and restaurants serve all customers, in a suit challenging a state law requiring a private club to admit women, and in a suit by the Boy Scout challenging a New Jersey law ban on discrimination on the basis of sexual orientation. Anti-minority animus is often packaged as religious liberty or another constitutional right, much in the same way as those seeking to end discrimination used the Constitution to achieve what amounted, at least in part, to social objectives. A fair critique of plainly reading the Constitution, therefore, is that it gives judges too much power because they can reach decisions without disclosing their true rationale. This debate around the originalist versus activist judges is, as I mentioned before, a central one among politicians and pundits discussing a president's Supreme Court nominee picks. It is not ivory tower theory, but nuts and bolts politics. Understanding what it means is vital to being able to participate meaningfully in the discussion around federal judicial nominees. And that was Chapter 4 of How to Read the Constitution and Why by Kim Wehle.